Good evening, everyone. My name is Benjamin Sanchez. This is another edition of Legal Grounds Live. It's Saturday evening. I'm about to leave my office, but before I did so, I thought I needed to talk briefly about something that's happened as of January 1st in Texas that is very relevant not only to my colleagues and the judges and attorneys, but also to anybody who has any type of litigation in Texas going on that starts January 1st or later. And that is this: the Texas Supreme Court has adopted new rules in terms of additions and changes to the Texas Rules of Civil Procedure that require disclosures now. And what this means is that before you could file a lawsuit in Texas or you could answer a lawsuit in Texas and you could wait to start doing what's called discovery. You could either start that on your own or wait for the other side to ask you certain questions and then you would respond to those. In Texas, in federal courts, we have had required disclosures for quite a while. And what that means is that certain information had to be disclosed by the each party to the lawsuit within a certain amount of time of the case starting. No ifs, ands, or buts. You didn't have to wait to the other side to ask you for that information. Certain information and documents were required. Well, the Texas Supreme Court now has a more of a federal looking model when it comes to disclosures. So we now have three types of required disclosures in Texas that you must be aware of. We have our initial disclosures, we have our expert disclosures, and then we have our pretrial disclosures. I don't want to get into the nuts and bolts of all these disclosures at this point. This video is simply to make you aware of the fact that your initial disclosures, which are certain information and documents, are required within 30 days of the first answer in the lawsuit or the first time someone makes what's called a general appearance. But suffice it to say, if someone answers a lawsuit in a county or district court in Texas, all parties, both the plaintiff and the defendant, have 30 days to serve their initial disclosures to the other side. In civil cases, we're sort of used to these disclosures. They haven't changed much, but now they're required. One side doesn't have to ask the other side to provide that information. Both sides have to provide it to each other now when they file the lawsuit. And as soon as that first answer comes in, 30 days passes, that's the deadline. It's also important to recognize and to realize that you cannot do any type of other discovery until at least the deadline for those initial disclosures. So we can't ask for requests for admissions, requests for productions, interrogatories, depositions, requests for inspections. All of that is off the table until at least the deadline for the initial disclosures are due. It's very important because it affects a lot of strategy. What's even more serious is that in family cases, there's a lot more information that is required than just the civil cases. So, in family cases, for example, you must have documents relating to your insurance. You must have documents relating to your bank accounts. You must have documents relating to your real property, the homes and things. You must have documents related to stocks, retirements, bonds, and those kind of things. And all those things are due, along with the other type of disclosures, 30 days after that initial answer. So this is really going to affect a lot of sort of legal strategy in terms of having those documents ready at the time that you file suit, because you want to make sure that you can answer those disclosures. You can provide those disclosures in a timely fashion. There is potential to have some sanctions if you fail to give those disclosures timely. And so when you're thinking about filing a new lawsuit now, you really need to think about those disclosures and whether or not you're going to be able to provide all that information by the time that those disclosures are due. I would say that when you should try to have all of that information ready at the time that you file the lawsuit, just so that everyone can get prepared and know that their case is solid going forward and being able to answer those disclosures or being able to give that information. This is very important. It's also important to know that all cases that were filed as of December 31st, 2020, do not have these required disclosures. So we're sort of in a two system tier right now because you have cases that were filed as of all the way through December 31st, 2020, that have certain discovery matters related to them. And then you have new cases as of January 1st, 2021, where all these required disclosures now exist. What we saw last month, and especially that last week between Christmas and New Year's, was a rush of new lawsuits being filed because attorneys and litigants wanted to get under the old system where they weren't required to do these disclosures. Um, for anybody who could not make that deadline, they now have to deal with these required disclosures. This earlier this week, I taught a class to various legal professionals online, and I went over the various new changes to the Texas Rules of Civil Procedure, which expand beyond just what I'm talking to you about, the disclosures. This month, for the next few weeks, I'm going to be coming online and talking about different aspects of those new rules so that you can better understand, as an attorney, you can understand those rules, but as a party, as a pro se litigant who's representing yourself, or as a client who has an attorney dealing with this, you better understand what's going on and the amount of work that is now required, which may also affect, quite frankly, some of the fee bills that you're seeing from attorneys, because now attorneys have to do much more work up front than they used to, and so they may be wanting a bigger retainer. They may want, to charge more down. They may just need to raise their rates altogether. So just be aware that we now have, as of January 1st, 2021, we now have required disclosures. We have three types: initial disclosures that are due 30 days after that first answer, with no discovery taking place until that deadline. We have expert disclosures that are due later in the process, and I'll go over expert disclosures in detail in another video. And then we have pretrial disclosures that are also due 30 days before trial, no matter what. So I'm going to go over all of these disclosures in more detail, but suffice it to know, you must be aware that there are initial disclosures. If you plan to file a lawsuit, especially if you're doing it on your own, be very careful, because if you don't do this, you could face sanctions that range anywhere from monetary sanctions to striking your pleadings to having the case dismissed if it gets worse enough. So that's my quick video for today. Be aware of the now required disclosures for all suits beginning January 1st, 2021. And I will go into more detail about all these different changes in the next coming weeks. Thank you for watching another edition of Legal Grounds Live. I like doing this, and I like educating my colleagues, and I also like educating the public. I hope you look forward to these next videos. They're going to go into a deep dive into all these changes. I wish everyone a very, very safe night and a happy Sunday tomorrow. Bye bye.